the Disbarment Proceeding 141 Scrap 51 by Florimond C. Rouse. In this annotation, it covers the cases involving issues and matters regarding disbarment, the specific issues together with the cases, which are distinction between disbarment and suspension, general principles, and the principles of breach of professional conduct. First is the definition of disbarment. Disbarment is the act of the court in withdrawing from an attorney the right to practice law. Meanwhile, suspension is the act of the court prohibiting an attorney from practicing law for a certain definite period. Also, the disbarment proceeding is a quasi-summary proceeding instituted and prosecuted before an appropriate court for the purpose of depriving an attorney of his license to practice his profession by reason of misconduct. Here we will have the differences between disbarment and suspension. The distinction between disbarment and suspension. As we said earlier, suspension is the act of the court prohibiting an attorney from practicing law for a certain period. Meanwhile, disbarment is the act of the court in withdrawing from an attorney the right to practice law. The distinction between the suspension and disbarment is that in suspension, the deprivation of an attorney's right to practice his profession is merely for a certain period, while in disbarment, the deprivation is more or less permanent. Another distinction or differences between suspension and disbarment is that in suspension, this power is prerogative vested upon the Court of Appeals and the Court of First Instance. Meanwhile, in disbarment, the authority rests exclusively upon the Supreme Court. And there are two primary objectives of disbarment and suspension. Again, it is to compel the attorneys to deal fairly and honestly with his clients, to remove from the profession a person whose misconduct has proved him unfit to be entrusted with the duties and responsibilities belonging to the office of an attorney. The purpose of disbarment is not meant as a punishment, depriving a lawyer of a source of livelihood, but it is rather intended to protect the administration of justice by requiring that those who exercise this function should be competent, honorable, reliable, in order that the courts and clients may rightly repose confidence. In this annotation, there are so many general principles for the disbarment proceedings, wherein I summarized all of them into three categories. Again, as I said earlier, I summarized the general principles into three categories, wherein we have the admission and disbarment, which pertains to admission and disbarment, and which also pertains to dismissal of the case, and also pertains to the acts of a lawyers that can disbar them. First, in the admission and disbarment, power to admit attorneys to the bar shall not be exercised, again, in a despotic manner, meaning it should not be exercised in a punishable manner. Power to disbar a lawyer and to reinstate him is a judicial function. Complainant has burden of proof. In disbarment case, he must present a convincing case in order to do so. Power to disbar attorneys always to be exercised with caution because of the serious consequences it may have. Power to disbar, bar discipline should be exercised on the preventive, not on the vindictive. Again, it should not be exercised in a despotic manner. Court shall protect lawyers from unjust accusation of dissatisfied litigants. The purpose of the disbarment proceeding is to safeguard or to protect the administration of justice by protecting the court and the public from the misconduct of officers of the court. The purpose of the disbarment is to protect the court and the public. It is considered closed and terminated due to the death of the respondent lawyer. Dismissed based on the same facts as the criminal case for which the lawyer was acquitted. Complaint for malpractice, deceit, and gross misconduct is dismissed due to the inadmissibility of affidavit of complainant's witness for being hearsay and complainant's disinterest in prosecuting the case. Cases are said to be dismissed for lack of interest of the complainant and the lawyer to prosecute the case. Complaint of disbarment is dismissed where appearance of a lawyer was made in good faith. I highlighted the main parts of this. Complaint for disbarment is dismissed when the complainant expressly admitted that his complaint has no legal standing or has no leg to stand on. Disbarment case against a lawyer for alleged immorality is dismissed, there being no witness to prove the charge. Upon withdrawal of complaint against lawyer by the complainant, the complaint is dismissed. Conduct of attorney outside his professional capacity which shows him unfit to manage affairs of others is a ground for suspension or disbarment, meaning that lawyers must always be fit to manage affairs and must always remain professional, must always be just in and out of his job or in his office. Again, as I said earlier, an attorney enjoys the legal presumption that he is innocent until proven so, or until the case have been decided. He is presumed to be innocent. Again, as I said earlier, as I summarized the general principles of the disbarment proceedings, I also summarized the breach of professional conduct wherein there is a breach of professional conduct if they are not in accordance with his oath of office, failing to appeal a judgment of conviction pursuant to his client's instruction, negligence resulting in the dismissal of appeals which has decisively prejudiced complainants who lost all recourses against the judgment against them, made a mockery of a marriage, does not meet the standard of a moral fitness for membership in the legal profession, continued to practice law despite the court's prohibition, falsifying the truth in his motion to dismiss, abandoning his lawful wife and cohabitating with another woman, uses abusive, abrasive, and threatening language, utterances of the Aike Bobo to a fellow lawyer is a breach of professional conduct, unethical manipulations to acquire a lot of his client despite withdrawal of complaint by the complainant, seducing a complainant into physically submitting to him by promises of marriage, and his imprudence to deny the paternity of his child by the complainant. Solicitation of cases, again, is also a breach of professional conduct. Concealing his name or using other names beside what is registered in the rolls of attorney is also a breach of professional conduct. Falsification of public documents also. As a government lawyer, acting on behalf of the government agency without the authority from its board of directors is also a breach of professional conduct. The using of language. Lawyers must not use language which jeopardizes high esteem in courts or creates distrust in judicial administration. The use of rude and repulsive language shows disrespect to the court. It is also a breach of professional conduct. Collecting an excessive amount of attorney's fee and alleged expense of litigation by taking advantage of his relationship with one of his clients. Preparation and ratification of an immoral affidavit or disgraceful acts which constitutes gross misconduct. And last here are also some useful readings or legal pointers that you may use when confronted with cases involving disbarment, which are provisions of Rule 138, Sections 27, the grounds for disbarment, 28, 29, 30, Rules of Court, and also Article 209, which is entitled The Betrayal of Trust by an Attorney or a Solicitor. It's Article 209 of the Revised Penal Code because this constitutes the basic law in any question or issue involving the subject matter, which is the disbarment. Here are some related annotations. Disbarment 98, SCRA 62. Decorum of a legal practitioner, the use of abusive language. It's not a ground for disqualification from membership in the bar. Disbarment, immorality is a ground for suspension or disbarment.